Hi everybody, it's Gina here again, helping you to take control of your future and get security for yourself and your family by making sensible estate planning decisions. Now you've heard me talk about wills a lot in all my previous videos. I'm going to talk about another very sensible tool today that you can use, and that's very kind of essential really to having a complete and rounded estate plan that takes care of all of your eventualities, and that's the lasting power of attorney. Now with a will, what you're doing with that document in essence is controlling what's going to happen in the event of your death. But if you don't get round to making a will, it's not exactly the end of the world, because we have here in England and Wales the intestacy rules, which means that if you die without a will, your next of kin can step in and can look after your affairs for you anyway. They're kind of automatically appointed. But what happens if you're still with us, but you lose the ability to make your own decisions about your life? You lose your mental capacity, and that obviously can happen as a result of getting older and having age-related illnesses such as dementia, but it can also happen because of other illnesses such as stroke or heart disease, or even being seriously injured. So this kind of terrible misfortune can pretty much befall any of us at any time in our lives, and if it does happen and you haven't made any advance arrangements to take care of what would happen in that eventuality, you and your family are kind of in limbo in a way, because here in England and Wales you are regarded as 100% in control of your own destiny, and if you need to make a decision about something, it's you and only you that can make that decision, and you have to have the capacity to make that decision. You have to understand what's going on and be able to make a proper decision about how to deal with any given situation. And if you lose that ability, there's no safety net, there's nobody that can be just given the role of representing you automatically, not even your spouse. You're in a weird situation where your family can't legally step in and make decisions on your behalf and sign documents for you or carry out official duties on your behalf unless they first go to court and apply to the Court of Protection for permission to represent you as your deputy. And that is a lengthy process. It takes months and it's pretty expensive as well. But what you can do is you can make a decision in advance to take care of what would happen. While you're fit and well, you can decide to appoint somebody to be your attorney by using a lasting power of attorney. You need at least one. You can have as many as you want actually, but it's sensible to kind of keep it at 4, because otherwise you're very much having a giant committee trying to make decisions about your life, which obviously is going to leave you in a situation of inertia, and it's probably not going to do you any good at all. So if you kind of keep it to your concise, sort of up to 4 people that you really trust, you can appoint them to be your attorneys. And to do that, what you do is, again, while you're fit and well and fully in possession of your faculties, you make a lasting power of attorney. Now, this is where it gets possibly a little bit confusing, because there are 2 kinds of lasting power of attorney. There is a lasting power of attorney for property and financial affairs, which does exactly what it says on the tin. Basically, it's there where you're appointing somebody, your attorney, to make decisions on your behalf about practical matters involving money, involving your assets, involving your bills perhaps, or access to benefits and that sort of stuff. And there is a lasting power of attorney for health and welfare, and that's where you are appointing attorneys or an attorney to make very personal decisions about how you will live, how you will be looked after, and what sort of medical treatment you should receive in any given situation. It even goes so far as to you deciding whether to give your attorneys the authority to decide when to kind of pull the plug as well, if you're in an end of life situation. So you've got the 2 kinds there, and what you need to be doing basically is thinking about, who do you trust? Who would you trust to step in and do a good job of ensuring that your wishes are respected, and obviously managing also the practicalities of your life if you are ever incapacitated by either illness or some terrible misfortune. Lots of people like to choose their spouse. You know, most couples will act for each other as attorneys, and as sort of secondary people, they will often choose their adult children, but also nephews, nieces, cousins, best friends. It's all about, look, who within your life is the person that you feel you could rely on if you're in trouble to really do the right thing for you and make sure that the outcome that you would have wanted is achieved, basically. You know, that's who you should choose as your attorney. Very often it's the person that you would choose to be your executor in the event of your death. You know, the executor of your will has a very similar kind of trusted role, has to be relied on to do the right thing for you and make sure that your wishes are respected, etc. Obviously the big difference here is that your will controls what happens in the event of your death, but your power of attorney controls what happens if you ever become incapacitated. You're still with us, basically. So you have to have the two. If all you do is make a will, you're kind of not doing the full job. You're only dealing with one eventuality and not the other. Now, a major fear that a lot of people have when they are making or considering making a power of attorney is, am I signing my life away? If I'm appointing this person to be my attorney, am I giving that person complete control over my life? And am I enthralled to that person from that point onwards? And also I see people who have already been appointed as attorneys kind of thinking that they're almost in a parental role to the person that they are attorney for. You know, it's, well, I'm supposed to be informed, and I'm supposed to consent to decisions that my relative or my friend or whoever, that my donor, that's who the person that's making a power of attorney is called, I'm supposed to have full control. I'm supposed to be notified, and you know, I'm very much at the centre of what happens in this person's life because I'm the attorney. Well, no, all of that is incorrect. Those are quite serious misconceptions, basically. When you, as a donor, appoint an attorney by making a lasting power of attorney, you are not really giving your attorney power over your life. What you're doing is you're giving your attorney responsibility and duty, and this is governed by some very detailed rules and regulations and a code of practice. But it all boils down to 5 central principles. The first principle is that your attorney is never allowed to just decide one day that you have lost your ability to make your own decisions. They have to always assume at all times that in any given situation you have the capacity to make your own decision, unless it's been established to the contrary. So how do you go about establishing whether somebody has capacity or not? The first port of call is your GP, or your donor's GP. GPs in practice day to day, they are, as a matter of routine, carrying out capacity assessments for their patients. And so if there's any doubt as to whether somebody has capacity, the GP is equipped and knows how to carry out a capacity assessment. Which brings us then to the next principle, which is that even if somebody, even if your donor that you are attorney for has impaired or lost capacity, it's not just like a light switch going on and off. You know, capacity is a movable feast. It's very situation specific. People have capacity to do some things and not others. They have capacity on some days and at sometimes and not at others, that kind of thing. So the second rule governs that, and it says that if there's a decision in front of somebody, you have to first of all support them as far as you can in making their own decision, if at all possible. And only if, with your help, they still haven't been able to make a decision, only at that point do you then consider stepping in and making a decision for them. So there's no jumping the gun. There's no, oh, I'm almost a parent to this person that I'm attorney for. Attorney and parent are not the same thing by any means. It's not a license to treat somebody like a child at all. Which then brings us to the third principle, which is if somebody wants to make a decision and that decision sounds silly to you, if you don't agree with it and you are their attorney, that on its own is not enough for you as the attorney to suddenly decide, oh, well, my donor has lost their capacity clearly because they want to do something daft. No, that's not how it works. Merely wanting to make an unwise decision is not on its own enough to say that capacity has been lost. It takes you back to principle one, which is, do we need to find out whether capacity is impaired or has been lost? But that's all, okay? And then the fourth key principle is that if you are making a decision for somebody, you've got over those first three obstacles and you are very much now having to make a decision in a situation, the only guiding principle is, what is the best thing for my donor? What is the best thing for this person for whom I am attorney? And it can't be clouded in any way by any other factors. What's best for me? What's best for the rest of the family, etc., etc. No, what is best for that person that I'm acting for? And the fifth and final key principle is that if you are making a decision for somebody that you are attorney for, and you've got a couple of different choices in front of you, you always have to choose the option that interferes the least with your donor's personal freedom and kind of autonomy, really. So as you can see, the 5 key principles are all about recognising really that England and Wales is a free country, that your donor is an adult, that you as a person making a power of attorney are an adult, and nobody gets to just take over your life and treat you as a child. It's there about maintaining your autonomy and respecting your autonomy as far as possible. Once those 5 key principles have been followed, your attorneys have got really wide scope to do whatever is right for you. They don't have that much in the way of restrictions on their decision-making abilities, but one thing they absolutely can't do for you is change or update or make your will. Once you've made your will, that's it, you know. You are the only person who can ever make or change your own will. And if you've made a will and you become incapacitated later, then your ability to change your will has gone and nobody can change it for you. And that's that, basically. But for as long as you've got capacity, if you've made a power of attorney, you've always got the right to change your mind. You can withdraw your power of attorney at any time. And the other key thing, of course, is that when you're making your power of attorney, it has to be registered with the Office of the Public Guardian, and they keep very detailed records about you personally. But the Office of the Public Guardian is under strict duties to maintain your confidentiality and handle your personal information legally and respectfully in accordance with the law, you know. So that is how a lasting power of attorney works, be it for property and financial affairs or health and welfare, and I hope you can see that it's a really essential tool for making sure that you've got all your eventualities covered, not just death but also incapacity, and obviously that you can cover property and financial affairs and health and welfare, and you're not signing your life away to somebody. That person, if they're following the 5 key principles, then they are maintaining your autonomy as far as possible, and they are making sure that your wishes remain front and centre and are respected. So I really hope that helped. For a bit more information, a bit more research, do please feel free to have a look at my blog on my website. I'll leave the link below for you. And of course, if you want specific guidance and advice as to your situation and the decisions that you're wanting to make, feel free to give me a call. Always happy to listen, always happy to share information. And my number is 0151 601 5399. Thanks again, then I'll talk to you again soon. Bye bye now.